Evening, everyone. This is Councilor Roby. I am going to call to order the City Council Urban Affairs Committee meeting. It is Tuesday, May 4th, and it is 7 o'clock. We have two items on our agenda. The first one is 21-100-8255, which is a request for approval of a flat wall sign for Best Value Kitchen and Bath, 796 Boston Post Road East within the Wayside District. We do have some, I guess I'm the only one, members that are on the Teams meeting, so I will call roll call to confirm the participation of all of the Urban Affairs Committee members. So Councilor Landers.
Councilor Landers here.
Councilor Doucette.
Councilor Doucette is present.
Councilor Navin.
Councilor Navin is present.
Councilor Wagner.
Councilor Wagner is present.
And I am present also, so we do have a quorum. Other councilors that are in the room, I see Councilor Irish. I believe Councilor Ossing is hiding in the corner. And are there any others that I cannot see? Councilor Perlman is on with me on the Teams. So that's who is with us right now. And I believe we have the petitioner, Mr. Maligny. I'm sorry if I'm pronouncing your name wrong. Are you with us?
No problem. Yes, can you hear me?
Yes, we can. So you are here with us tonight because although your sign looks fine according to the building department, you are in the wayside zoning and you are requesting a sign with internally illuminated panels, which goes against the sign code if we can have them done without the internal illumination. So what you submitted was sent to us. I believe you had sent some information to our assistant, Ms. Bully, with a possible change. I did ask the city clerk to have it available to show on the screen because I do not know if other people had received the information or if in fact you are moving to change what you were going to be putting up.
So the change was to not illuminate the sign.
Okay, so I drove by there, and of course I did it during the day, so I do not know. You are in a strip mall with multiple other businesses with signs. I don't know if theirs are currently internal illuminated. If you are not internally illuminated, I don't see any kind of a light that would be above the sign that would allow this to be seen at night. Are you okay with that?
So the way that the building was redesigned by the current landlord a year or two ago, there isn't really any place to put any kind of lighting, like gooseneck lighting or something along those lines, which was why we were originally looking to get a channel letter illuminated sign. At this point, we are looking to put a sign up. So if we are not allowed to illuminate it, we wouldn't be opposed to removing that aspect in order to get the sign approved.
Okay, so I'm going to read as the building department had sent to you. It does state, except as otherwise provided, signage shall conform to the provisions, and signs, logos, or cabinets should be externally illuminated where possible. So you are trying to meet that. I don't know if there are counselors on the committee with questions or statements that they would like to bring to the applicant. I'm going to open it up.
Madam Chair, it's Councilor Doucette.
Councilor Doucette.
Thank you very much, Madam Chair. I think one of the last things you said is basically where possible. You know, I know this mall very well, and you know, yes, they just did a refacing, and with that, eliminated that as an option as far as easily externally lighted. I'm not concerned about if we allow them to light this one as an exception to the rule.
Thank you for that information. Anybody else with questions or comments?
Councilor Roby, Councilor Navin.
Councilor Navin.
Thank you, Madam Chair. Just to be clear, this will be the only business in that strip mall that would not have an internally lit sign, is that correct? Did I misunderstand that?
I don't know for sure. As I said, I went by the mall. Maybe Counselor Doucette knows more or the applicant knows, but my looking at the signs that are at the other businesses, they probably are internally illuminated, but I guess it's also possible they're not because.
Correct, they are.
They are, okay.
Yes.
Okay, thank you, Madam Chair. I would share Councilor Doucette's thought that I would not be opposed in this circumstance to give the applicant the same benefit as the rest of the business owners in that strip mall.
Okay, that was kind of where I was coming from after looking at this, and I apologize for doing it so late. I do notice that there is I'm not sure what they're called, a tall banner sign, if that's not the right word. It's a sign that's on the corner of the property that has also a listing. Did you plan on having signage added to that? Because I don't believe that's part of this package.
We did not at this time. We may in the future, but we would apply for that separately.
Okay. All right, so you have been kind enough to give us information for putting this in without internal illumination, but we also do have the information that was submitted with the packet from the building department that does show everything internally illuminated, which sounds like maybe an agreeable application considering the rest of the property. Is there anybody else who wants to weigh in? Anybody who wants to make a motion? Oh, sorry.
Chairwoman Roby, this is Councilor Wagner. Can you just refresh my memory for the one that's illuminated? Is it freestanding letters like this that have the illumination inside, or does it, I can't remember what the other design was like, or was it more like a big box that was illuminated and the letters are on it?
I believe it's exactly like what we have now. If you don't have your packet, I think, I don't know if.
I have my packet. You're talking about a previous, I don't have the previous, I can't remember the previous one.
It's new business.
The previous one looks pretty much like what we have, what I think the clerk had shown on the screen, other than the fact that it is not.
Okay, so then these letters would have the lights inside. And can you clarify for me, are they fixed to the building, or are they somehow mounted on the edge of, like, the ledge and separate from the building itself?
That I think the applicant would have to tell me. I'm guessing that they're on the building.
So that ledge extends out a couple of feet off the building. I don't know the exact dimensions, but probably around 3 to 4 feet off the building. So the channel letter sign, like is on the screen, sits on top of the ledge right at the edge of it. And that's actually how all of the other signs are inside this plaza as well.
Oh, okay.
And you're right, looking at my picture that I took today, it does show them. They're kind of up in the air, and it's deceiving looking at this picture because it looks like they're actually on that white clapboard that's up above, and they're not. They're away from that.
Correct.
And I believe the size is the same. The only difference is that this one shows not being internally illuminated, where the original one does. The sign specs have it being internally illuminated.
Madam Chair, motion to approve as being lit, modified to be lit, is that, what would be the proper phrase for that?
I guess I would just say move to approve as submitted.
Okay. Motion to approve as submitted.
Once the building department knows we have approved it, they can then give the sign permit. So there's a motion on the floor to approve as submitted. I will second that. Is there further discussion from the committee members or anyone else? I am not hearing any since I don't have a full view of the chamber. So I'm going to take a roll call vote. Councilor Wagner.
Councilor Wagner votes yes.
Councilor Doucette.
Council Doucette votes yes.
Councilor Navin.
Counselor Naven votes yes.
Councilor Landers.
Councilor Landers votes yes.
And Councilor Roby votes yes. So that is a 5-0 vote. I thank you very much for allowing this to go through. And this will be on the agenda for Monday. I can either report it out and let it lay on the table, or I can ask for a suspension. Is there any objection from the committee to suspend so this can get finalized and he can have his sign up?
Fine with me, or approve?
No objection.
No objection.
All right, I will ask for a suspension on Monday, and hopefully the full committee or the full council approves this, and then the building department will know, and you should be able to get your sign permit.
Awesome. Thank you for your time this evening.
All right, thank you very much for your patience with us as we go through the process.
Not a problem. Appreciate it.
All right. So the next item on the agenda is order number 21-108-2222, which is an order that the city solicitor be invited to a future urban affairs meeting to provide general information regarding the approval and denial of special permit applications that may be referred to the committee. We do have Solicitor Grossfield with us. He does have about 15 slides that he has prepared. I would ask the indulgence of the committee to let him go through the slides. You've had this presentation. If you have questions, we'll have plenty of time when he is finished to ask them. So, Solicitor, if you're ready. And your microphone is still on mute.
Good evening, everyone. Thank you so much for the opportunity to be before you tonight to discuss the special permits, approvals, and denials. Just want to make sure you have the slides up before you on your screen.
We had them up, but they're not there now. Now they are.
There they go. Thank you very much. So I appreciate the opportunity to speak to you tonight about special permits, and thank you for the invitation to do so. Tonight, generally, as you see from the slides, we're going to cover the fundamentals of what makes a special permit special and what the role means when the council is serving as the special permit granting authority. And it's a unique subject matter, but it's a substantial part of the council's business. And I'm happy to discuss any questions as as we talked about at the end of the session. Perfectly fine. I am going to speak in generalities tonight, not speaking on any particular application that has been or was before the council, but I'll talk in generalities about special permits and some of the case law around them. So to give a little bit of context for special permits, they emanate from the State Zoning Act, which is Chapter 40A. And to think for a second about zoning, zoning is essentially the local laws that regulate the use of land, buildings, and structures. And one of the ways in which we do that is through a special permit. So as the council knows, here and in many communities, we have a zoning map, and essentially the city's map is based upon districts. At last count here in Marlborough, there are 14 different zoning districts. Most recently, the Wayside District was adopted. And in each district, as you look through the table of uses, you see that there are certain types of uses that the council has established, whether it's residential, commercial, or industrial uses. Some uses are permitted, other uses are prohibited. And then there's a class of uses in each district where, by special permit, under the right conditions, that use will be allowed. There's also a number of overlay districts, as the council is well aware, and those are additional land use regulations that are superimposed on an underlying district. In addition to the use provisions that we just touched upon, there's also, of course, dimensional regulations which will govern the land and buildings And there are some times where the council has the authority to modify dimensional requirements by a special permit process. In general terms, the special permit is the process by which there's some flexibility for a use that is not automatically permitted by right, but is often a use that is desirable or even necessary in a community. And when it's conditioned to be compatible, consistent with the zoning ordinance, is when a special permit is generally granted. And one thing I want to mention also is there's, of course, site plan review, which is a different type of is a different type of review process, which shapes the details and the specific details of a use. And site plan review is often triggered with a by right permitted use, but it also comes into play on certain special permit projects. And here's the table of uses, as the council's well aware, and you can see as you go down and you pick the district and you pick the type of use that you have, the SP indicates where a special permit will be required. So for example, on this chart, where if we're looking at a multifamily dwelling type of residential use, and you scroll across the row, you can see I've highlighted, you can see the districts where it is by special permit. So the general process, as the council is aware, is you start with an application. An applicant will file it. The city zoning ordinance sets up what needs to be in that application. There will be a public hearing and notice of that public hearing. Then, of course, the council or the Urban Affairs Committee will deliberate on the application itself in a public meeting. And ultimately, a decision will be rendered containing the findings, any conditions that the council deems appropriate. And a lot of times here in Marlborough and in many other places, the applicants will prepare the first draft of the decision. And the goal at the end of the day for, of course, the council and for our office is that the decision is legally defensible. And we'll discuss some of the pieces that go into that later on. But the applicant, in doing the first draft, of course, also shares the goal of obtaining a special permit that is legally defensible. So one thing I want to touch upon briefly, and I know I've sent previous guidance on this, but the voting threshold for certain types of special permits has been reduced down to a simple majority vote rather than the customary 2/3 vote. And this housing choice law is part of the state economic development bill, which passed approximately 4 months ago. So it's relatively new, and we're still awaiting regulations from on a number of points from the state. But these provisions are in effect, and particular to this presentation is the fact that certain special permits for multifamily housing, which is located in proximity to certain public transportation and provides for affordable housing, as well as mixed-use developments, which is a mix of residential and commercial uses in areas of commercial activity within the city, phrases that are not specifically defined yet, but they also, if they're meeting the affordable housing requirements, are just a couple of examples of special permits that now are subject to reduced voting requirement. And I will note on that front, the state guidance so far is silent as to who in a city or town will determine the voting threshold for a special permit. And our office intends to provide an opinion to the council when, at least at the time when we're sending down the decision into legal form, to indicate whether we think it is a majority or a 2/3 vote. So I want to turn a little bit to the basis for issuing a special permit. And this comes from our zoning ordinance. The general required finding, which you see in the silver box, that is the criteria that the council has for its special permits. And there's a couple of zones that have some additional criteria, but this is essentially the primary test that the council will need to apply and does apply on special permit applications. And you can see it's that the use that's proposed and its impact and characteristics will not be in conflict with public health, safety, convenience, and welfare, and will not be detrimental or offensive, provided the conditions, safeguards, or limitations imposed, if any, are met. Now, to read that's a sort of touching on a variety of subjects that could impact any number of things. but you would generally read that required finding in conjunction with the whole purpose for the zoning ordinance. And you can see in the orange square or rectangle I've outlined from the zoning ordinance what the purpose is. And that sort of to give some guidance to what the reason is for this general finding and how that ties into the zoning ordinance overall. So those are your general guideposts when you're looking at a special permit application. And the primary function for the council in considering that criteria is to apply it to the factual information you have before you in the record. So for example, if during the public hearing process, you take in a substantial amount of information about traffic data, and one of the criteria that I just mentioned is that the criteria being that the use won't conflict with public safety. Well, one thing the council may be looking at is what does the traffic data say about an intersection? Will it produce a dangerous intersection result if the use is permitted? And that essentially is the key when the council is considering these applications, is how has the applicant proved to the council that it meets the special permit criteria? And it is the applicant's burden to do that. And it's perfectly acceptable for the council to say to any applicant, show us, walk us through, explain how the proposed use meets the special permit criteria in the zoning ordinance. And on the flip side of that, if a special permit application is denied for a reason which is not in the criteria we just went over, that's where a decision will be vulnerable to challenge. So this is another example. This is from the Wayside zoning district, where there's an additional piece of criteria amongst a number of additional parts, but quality of design. And so how might the council look at quality of design in the Wayside district? Well, you might look at renderings, drawings, plans that are explanations of the types of materials that will be on the exterior of a proposed structure and what will be visible from the street. That's the kind of factual piece that you match up with the criteria in the zoning ordinance to apply in the context of a special permit. So oftentimes a special permit is said it is in the local board's discretion, the council's discretion. But there are a number of caveats to that. And a lot of these caveats develop over time through court decisions. So for example, of course, it's appropriate to consider impacts associated with the proposed use. So what are the impacts that the proposed use are going to cause to the community at large? Another example is whether or not the council wants to vary a particular dimensional limitation, even if it's authorized in the zoning ordinance, doesn't necessarily mean the council has to go to that extent. But the red flags on the other side are looking at things outside of the zoning ordinance, including things such as the reputation of an applicant. For example, the idea that, oh, this applicant for the special permit has had a number of zoning violations on 10 properties across the state in the past is not a piece of the criteria that courts have recognized would carry the day. Similarly, if you're looking at an application and considering factual information that's not formally before the council in the record, those facts are, by not being in the record, they raise an issue with a special permit decision where the applicant hasn't had the chance to necessarily know the facts that the council is relying on in advance of the decision. We'll talk a little bit about conditions, and many of our decisions have conditions. And by state law, we have authority to impose conditions as long as they're in line with the interests in both our zoning ordinance criteria and the whole purpose of the zoning ordinance. So there's a wide variety of examples, from hours of operation to when construction will get started, to when substantial use will commence, and the list goes on. There's also examples of conditions that have been challenged by applicants and have been struck down. And those are the kinds of conditions that really have no connection to the special permit criteria, or there's sort of these larger community problems that are either not directly tied into the use, or it's not specified exactly what the specific condition will require the applicant to do from the decision. And conditions overall are a way of addressing impacts from the project, and in a very effective way, especially with a special permit. But at the same time, they run against, there's a limit to the kind of conditions that can be imposed. So sitting in this role of a special permit granting authority is unique. When the council functions in this capacity, it's no longer acting in the legislative sense, but rather in a judicial or quasi-judicial role. And essentially, the permit applicant has a statutory right to an honest, uninfluenced opinion rendered in good faith about deciding whether the special permit should issue. So that means a number of things for the council, and councilors will want to keep these things in mind. It is really setting up a fair process where an application is not prejudged. There's not susceptible to a suggestion that there's bias for or against a particular application. And that can extend to making statements about a particular application outside of the public meeting. These are things that we want to make sure. It's essentially, if you think about it, as if you were in court in a judicial forum. The council is taking in the facts on the record, deliberating on the record in an open session, and rendering its decision in an open session. So if you think about it that way, it's vital to make sure that the process, integrity of the process is maintained. And this, to me, is a growing area of the law that we're going to continue to see across the state. More court actions brought by disappointed applicants generally, who try to attack the process itself. And so I can't emphasize enough the ensuring that it's really a fair, neutral process. And ultimately, of course, the council will make a decision on an application, and that's perfectly within our right to do so, but making sure it's done in a fair and neutral way is appropriate. So we talked a bit about the decision process earlier, right? And there's really two outcomes that I wanted to touch upon, is the grant or the denial. And the courts view them as requiring different things. So when you're granting a special permit, detailed findings are necessary to support the decision and to show why the proposed use complies with the criteria. And that is one of the reasons why when we have decisions drafted, as I mentioned earlier, the applicants are generally trying to supply those facts that are in the record. And that also plays into if a court challenge took place down the road from a grant of a special permit. Oftentimes in court, the applicant, the successful applicant in that case, will bear the brunt or the burden of defending the grant of the special permit. And the legal department for the city or town will be sort of a nominal party, it's called in most courts, in the case, but monitoring essentially and making sure that the city's interests are protected. On the flip side, in the case of a denial, it doesn't require detailed findings, but it does require providing reasons that are beyond sort of parroting, oh, the general criteria hasn't been met. So it does require specific reasons, and when local boards or councils deny special permits and they don't put reasons in, a couple things happen. One is there may be a remand back to the council or the board to provide those reasons. Or another is the court essentially says, we're not going to go searching for the reasons that the local board or council didn't, decide to clarify in their decision. And that obviously can cut against sustaining a denial. Ultimately, in either case, there's a written decision that's issued. It gets recorded with the Registry of Deeds, And our office, as you know, reviews those decisions prior to that time. So special permits end up in court in a number of ways. These are kind of the most common is an abutter appeals a grant of a special permit. And in that case, a lot of times what you'll see in court is a challenge to what they call the legal standing of the abutter to file an appeal of a grant of a special permit. And the courts have developed a test that the abutter, who's the appellant, has to demonstrate that they themselves are particularly an aggrieved person. And it can't be predicated on speculative personal opinion about subject matter like noise, traffic, pollution, variety of subjects that may be the basis of an appeal. It has to be demonstrated damage to the plaintiff in particular, rather than just trying to generally enforce the zoning ordinance, which applies to anyone in the community. The other primary way special permits end up in court is the applicant appeals a denial or appeals a portion of a grant, which is the conditions generally. When the applicant appeals a denial, we're going to talk a bit more about that in just a minute. When the court looks at a special permit decision from a local body, the court is going to determine the facts fresh. It's not going to be deferring to only the facts that, or the facts that the council or the local board determined. So the facts all come in anew. And the court will generally give some deference to the special permit granting authority unless it's based on a legally untenable or arbitrary ground. And the way the court figures that out is, one, the court looks at, hey, did the local special permit granting authority apply the correct standards and their criteria in the zoning ordinance? So if criteria was used that nobody can find in the zoning ordinance, that's gonna be a major factor at that part one step. If the court finds that part one is met, essentially part two is where the court will largely defer to the local body unless the court finds that there's really no rational basis for the facts as the SPGA or the Special Permit Granting Authority determined. There's no facts to back up the decision. So that scenario is, well, on the local level, we thought the sky was blue, or we thought the sky was orange and blue, and the court says, nope, the sky was blue that day. That's the kind of situation where on an undisputed level, there's no facts to support the local decision. And that's the part two analysis. So I'd like to walk through a couple of recent cases which sort of demonstrate some of what I just spoke about. These are land court cases. I'm going to touch upon two of them and kind of walk through what happened, just to illustrate a little bit more as to how these kind of situations play out. A couple things I'll say: these are land court decisions. They are recent, so they are not the same effect of law as cases that have gone up to the appeals court, but they're pretty instructive, and the land court generally issues very detailed decisions on these that I think will be helpful. So here's the AAA Northeast versus Peabody City Council case, and this just came out the end of March. This was an application for a special permit for a trucking terminal and a service center in a commercial district. This got, sort of the opening line of this court's decision is, the saying is a baseball metaphor, which is essentially, it's hard to get a hit when you have 2 strikes and a 3 against you. And it'll become more clear what I mean by that. So on the first go around, the city council, the special permit granting authority for this, denied, citing to 3 reasons against the truck terminal. There's no desirable need for a terminal. It'll exacerbate traffic, and it'll lead to further illegal motor activity in the area. Well, it went up to court, the applicant appealed, and the court by agreement, the court sent the application back down to the council to reconsider. And part of the agreement was, particular to the traffic issue, the applicant was going to provided a further traffic study by an engineer, and also pay for the cost of the city to have a consultant peer review that report. So when it went back, the council held a hearing and considered this a second time around, and this time denied it again, but it switched up the lineup, and it essentially dropped traffic congestion, dropped motor vehicle activity as reasons, and replaced them with more or less 2 new ones and 1 expanded one. So failure to submit a site plan, outdoor storage not being allowed and contending that the applicant had made a statement to the contrary, and failing to meet the general criteria about special permits in their zoning ordinance, which dovetails with the local need reason that they referenced in the first go-round. And the court looked at it and essentially said, one by one, it ruled that as a matter of fact, that the applicant had submitted a special permit and that the applicant had not proposed to store unlawful products outdoors. So those are reasons 1 and 2 were not able to survive because as a factual matter, there was no basis for them. Reason number 3, they essentially said that the council didn't offer any explanation for why it failed to meet the general criteria about not being desirable or the appearance being outside of harmony with the neighborhood and the area. And so there were no facts in the record and no explanation from the council about why they couldn't meet that criteria. And so ultimately the council, and a lot of times it's said that this rarely happens, but it has happened a few times over the last few months. The court ordered the council to issue the special permits for the project. And this was a situation where the court found there was no factual support to back up the 3 reasons that were proposed. And as to the traffic issue, the court and the council essentially admitted this in court, is that the traffic issue was reviewed by both a supplemental report from the applicant and the city's traffic consultant, and it was not demonstrated that there were any traffic issues. And the court said by not including that in the reasons the second time around, that there was no longer an issue to be decided on traffic. This is another recent decision. This is Basque Inc. versus members of the Taunton City Council. Again, the council was the special permit granting authority in Taunton, and this took place at the end of 2020. This was a special permit application for retail marijuana on a state highway in the highway business district. The council denied this special permit, citing to traffic concerns that the proposed use would create additional traffic on an already busy state road and intersection, and essentially would create a nuisance and a hazard for vehicles and pedestrians, and exacerbate what was a large backup, particularly at the evening rush hour. And the council wrote up this decision, the denial, hinging on the number of additional vehicle trips expected, and citing to a traffic light that had been installed down the road from the site, sounds like several months before, and which apparently was due for some signal upgrades to make it work, but those hadn't been implemented yet. The council also cited to its general criteria to support the denial, saying that, essentially quoting back in their decision the general criteria and saying that it was not met. Similar to the last decision, the court found that there was no explanation to why facts in the record would show that the proposed use was not in the best interest of the city, and that the proposed use wasn't in harmony with the zoning district and the ordinance. And the court also reiterated that when denying an application, if the council is going to rely on its general criteria, it can't just be parroted back support a denial. There needs to be factual information to explain what the rational reason is why it's not in the best interest of the city. And that was something that wasn't done here. And there was an additional layer to this case, which the court was critical of the council in time, saying that essentially the court felt like there was an unspoken pretext to their decision-making process. And the court's basis for this is that 4 months after this special permit was denied, another applicant down the road also for retail marijuana sales and a larger project was approved without even the need for a traffic study. So the court read into that approval, and the council couldn't distinguish why this one would be worse than the other one in terms of traffic or any other impact, as saying there was a pretext there that had no basis in the criteria for the zoning ordinance. The last piece on the traffic piece overall, when the matter went to court, the applicant had a traffic engineer testifying that there would be no proposed impact that would worsen an already bad situation, and that any increase would be de minimis. So, for example, there was a suggestion that the level of service of the intersection would drop down one letter from a B to a C, and the court determined that the number of trips involved would be de minimis relative to the overall traffic situation. And the city could not rebut the traffic engineer testimony, so could not provide anything to the contrary to show that that wouldn't be the case. So this was another example of a situation where the council had a denial where the findings of fact were not there, but there was additional layers to it that the court determined that the special permit should have been issued and ordered it issued. So with that, I'm happy to answer any questions, and hopefully I didn't run through this too fast and that it was helpful, and happy to answer any questions.
Thank you, Solicitor Grossfield. So I'm going to open this up first to questions from the committee. I do believe we do have Councilor Dumas with us also on the Teams meeting, so I will recognize him later if he has questions. So from the committee.
Madam Chair, it's Councilor Doucette.
Councilor Doucette.
Thank you very much, Madam Chair. I do have a couple of questions as far as bouncing around through it. I'll try to keep them in order based upon the slides. When you referred to mixed use, so the idea basically the Wayside District is currently a mixed use district, right? So the idea is to combine retail and housing into the same building structure. That's kind of the view of mixed use. Is that correct? You're on mute, Solicitor Grossfield.
Sorry about that.
No worries.
Through the chair. So mixed use has a definition in our zoning ordinance, and essentially that's right. It's taking a parcel and having a number of different uses, not in any particular proportion. It's not 10% this use, 50% this use. It's not that specific, but it is a project that's not just one use and is going to be done in either the same building or a number of buildings.
Okay, thank you. The other point is you talked about not having problem, or if you have vague problems to be fixed, they don't necessarily like that. On the other hand, if let's say we were going to put, I don't know, $50,000 to the next fire station as a special permit condition, that would be allowed, correct? Arbitrary value.
Good. Sorry. So that can be a very specific condition that you mentioned there, right? Is trying to essentially fix a particular problem when you say new fire station in the neighborhood. The caveat to contributions like that is that they essentially have to be voluntary. We run into, if they are imposed unilaterally, you can run into constitutional issues with the phrases exactions. So we always want to be careful with those kind of conditions, but a lot of times what happens is the applicant will propose it on their own initiative, and that's acceptable.
Okay, thank you very much, Madam Chair. That's done for me for now.
Thank you. Other counselors on the committee? Counselor Wagner.
Madam Chair, thank you, Madam Chair. I'm struggling with trying to find, the solicitor brought up using factual information, but sometimes it's an understanding of I'm seeing a disconnect between our role when we make these decisions, and it's not always going to be by the numbers. It meets these 3 criteria, so therefore it's a go. It only met 2. It's not that simplistic. So things like we're supposed to look at safety, convenience, the welfare. It's subjective, and it's part of our role to understand. Like, so I'm a ward counselor. I would need to make these decisions within my ward and listening to constituents, and there's a lot of factors to take into consideration that aren't always measurable by a study. And I find myself thinking, so if a project was going in and there's a high probability based on the design of the project, there's going to be a lot of noise, which is going to impact the neighbors, but there's no definitive study that says for how many hours, for how many, like you can't, it's not that tangible. So therefore we have to approve it, and then the noise is there and it like ruins the community is now miserable, and we have to say, oh, well, our hands were tied. That seems like a failure of our role, and I'm not understanding the distinction between that criteria, because if it was that simplistic, you wouldn't need human beings sitting here. You could run it through a computer. It meets these 3 criteria, boom, approve it. You don't even need people to talk about it. So I'm finding this very frustrating. Can you say more about that?
Sure. So through the chair, so for example, I think the issues that a lot of local boards will run into is if there is a way to quantify the data, right? So take the noise concern, for example, right? There's ways to establish, and there's noise engineers, and there will be noise consultants who will do decibel testing or decibel modeling from different distances. So the concern is when you really drill down to whatever the particular application is and what the issue is, right? Whatever the perceived impact is, making sure that we can determine whether there is a quantifiable data point. Because if there is, and I understand what you're saying, some of it is knowledge of the neighborhood and the community, but the flip side of that is if the applicant is going to produce a noise report and it's going to establish that, for example, hey, my proposed whatever XYZ, my noise consultant says the sound won't go beyond the boundaries of the property. Well, that's going to be a problem for us on the local level if we can't rebut that with any kind of data. So I hear what you're saying. You're coming up right where there are impacts that are recognizable in the community, but the flip side is there any data that can be developed to show on the part of the applicant that it won't be an impact, or does the city need to require some data to be showed that there is no impact there?
Can I just ask a follow-up question then? It feels like it's a battle of theoretical data. So a study could come in, like traffic is coming to mind, and there's the realities of a situation, but like traffic studies, and I've seen this where there's been studies and there has to be 8 different segments, 8 hours that meet all the criteria, and you could have 7. It's bad enough to meet 7, but it's not 8, so now that's not good enough. And there's a theoretical part of it's projected about what the traffic will be like. So whose theoretical data outweighs, I mean, it could be the other side of that coin too, is the projection based on someone else's projection, it is going to be a problem. And then the other extra wrinkle of COVID right now, so if there was a study being done like that, it's very difficult to dispute it because we're not probably going to have really same level pre-COVID rates, and could be another couple of years. So there's no way to even quantify that now. So it feels like an extreme disadvantage for the community that exists where a project is being proposed to go.
So through the chair, so that's a great question. So for example, say you had dueling noise consultants, right? So you had an applicant who produced a noise report, and the city had a noise engineer that peer reviewed that report and said, well, I disagree with what the applicant's analysis was, or I disagree with the outcome or the scientific method used. That's perfectly acceptable, because there you have a rational basis to hang your hat on to say, okay, there's dueling experts essentially, but there's not one way to analyze the data. It's the other side of that coin is, where I think I mentioned was one of those cases is where the peer review, the city's expert doesn't disagree with the applicant's expert. And so then there is no plausible dispute over that data. That is where the court will say, hey, look, you're saying there's a noise situation here that can't be solved. But then at the same time, you got two sides of experts saying that, no, they agree that it won't be an issue or could be solved. So that's the kind of dichotomy you have there.
Thank you.
Sure.
Madam Chair, Councilor Navin.
Councilor Navin.
Thank you, Madam Chair. Mr. Solicitor, thank you very much for putting the time into this. This is very helpful for me. Two questions. One is kind of in the minutia. You had a slide up about the new housing choice law and what the new thresholds are going to be for voting. One of them we talked about kind of, proximity to commuter rail stations, subway stations, bus stops, et cetera. Is it clear? So we have bus stops in the city for the MWRTA. Are we included as well in something like that, or is that still regulations that are going to be coming out?
It's a great question, Councilor Davis. So that's one of the things that I think we could benefit statewide from some clarification about. So for example, if we parse that language, there are not necessarily any bus stations in Marlborough. There certainly are bus stops, but those are arguably two different things. And so there's not a clear cut. Sitting here today, we wouldn't necessarily fold them into each other. So okay. Good question.
Okay, that's helpful. Thank you. And then just on the examples from the land court cases that you shared, when the court orders an issuance of a special permit, is the rest of the permit upheld? Are the conditions that the SPGAs have already included in them, are they held up as well? And it's just the issuance? So it's the issuance of the permit as it was, I don't want to say negotiated, but discussed and then amended, or is it some other version of that?
So through you to the counselor. So in those cases, what could happen is those were denials, so there were no conditions imposed. So essentially, those are being ordered to be granted. Sometimes in a case where if it's a different posture, they could be remanded back to the local level to say, because maybe a condition was challenged, but not the whole special permit. So in that situation, the local board may have a second bite at the apple to say, okay, condition 4 and 8 were held invalid or were remanded back, so we can look at those in the context of maybe some additional data. Sometimes the parties will agree to jointly remand without getting too far in court, especially if the project is going to change based on an appeal. There may need to be another public hearing. So there's a number of ways that could play out, but in those cases, there were no conditions.
Okay, thanks. I didn't know if it was, as it went through the process, even though it was denied, I didn't know if the document that was voted on then became what was enforced. So I appreciate that. Thank you very much.
Sure.
Councilor Landers, do I see your hand?
Yes. Just quickly, Madam Chair, and Jason, you've been here a couple of years, so I don't mean to reflect our city solicitor's office here. But I've been on the council, I think, 14 years, and we've had some court cases, all right? But overall, in my 14 years, I think we've done pretty well. Does that mean that the city council and the city solicitor's office has done a good job? I mean, I'm not asking you, because you, maybe, this is before you came. I mean, we've been, and we've certainly given out a lot of permits, and, we've had a few wrinkles, but my observation is that the city solicitor's office and city council, the leadership of the city council, we've done pretty well. Do you care to comment on that, or would you rather skip over that?
Through the chair, I think that's a fair thing to say. I think, that can't be said in every community. And, ultimately there could be any number of appeals to a special permit. That doesn't mean the appeals will be successful. But I think that's right. I think the council has done a thorough and well-informed job of fulfilling this role, and the decisions reflect that. And that's how you end up with a track record like that. So I appreciate that.
Madam Chair, do you agree with me somewhat on that? You've been on, I think, the same amount of time that I've been on, I think. Do you think we've done pretty good over the years?
Councilor Landers, I would agree with you. I can only remember one actual lawsuit that went all the way through that the city council was successful in. We were threatened with a couple of times, but
yeah, the threat's been there. Yeah.
As far as I know, we've never been sued for any denial of a special permit, except for one.
Yeah, and I know,
But I don't know how many we've denied either. So that may be part of our track record.
Thank you.
Thank you, Councilor Landers. I see Councilor Perlman has her hand raised with questions.
Thank you, Madam Chair. I have a couple of short questions. Kind of wanted to build off of some of the points brought up by several other councilors to ask follow-ups. So I know Councilor Wagner raised the concern that some things like traffic or a different kind of situation, there needed to be studies or data, and how some of that could be also subjective. I'm curious, I know you mentioned the burden on a lot of things is on the applicant. So in the case of running a study, if a municipality wanted to have oversight over that or be able to do a different type of study, I'm just wondering, because there's a cost burden associated with that, and so I'm just wondering how that is reconciled in the situation, because then the burden is also falling on the municipality to give that oversight. And I'm curious, if you could just speak to that a little bit more of the breakdown between, who's responsible for what.
Sure, that's a good question. So there is a procedure under state law where a municipality, the local council, the board can retain outside experts and consultants at the expense of the applicant. And that's oftentimes the kind of process that's used when a community goes to peer review a traffic report or a noise report or another type of report. And a lot of times it's used for engineers, consultants in particular specialties, depending on the project. So there's a procedure. It has to get adopted on the local level, but it's available. And then there's a mechanism by which a consultant can be designated by the local board, council, and the cost can be dealt with through through municipal finance as well. And it works in many communities. It's used, and it's an effective tool, like you say, for a process that otherwise could be a very significant burden to the community. And sometimes, that, like any procedure, it's not perfect. So there can be conflicts about, the cost is too high or the scope is too far. So those are things that play out across the state, but there is a process that can be used.
Thank you. That's very helpful. Another question, and I know you mentioned that oftentimes a city council in a municipality is the special permit granting authority. Is that not always the case? And what are examples of who else holds that position, as well as within the cases that you mentioned? I'm curious the timeline of how long that occurred over, if there was an initial denial and then it had to go to court. I was just curious the timeline.
That's a great question. So the span of who will be the special permit granting authority will vary from community to community. It's established in the zoning ordinance, And generally it's essentially one of three entities. It will be, in a city, it'll be the council, or it'll be the zoning board of appeals, the ZBA, and the planning board is another common option. And so, here in Marlborough, there's actually certain limited special permits that are split out from the council. And in other cities, you can look at, and they vary. In some places, the council is the SPGA. In other places, the council is not the SPGA at all, and it's all with the ZBA or the planning board. So it runs the gamut in that front. To your question about the timeline, so it depends on a couple things, probably most notably where somebody files in court. So the land court, which is a specialized court that really only hears disputes concerning property, they have a very proactive approach when it comes to case management. So when a case gets there, they very early on will hold sort of a pre-conference essentially to get the parties and the attorneys essentially in the room to size up the case and what this case is going to be about. And from there, they'll set the tracking order. But it moves along relatively quick, depending on the amount of information that has to be developed on either side. So it can be a couple years ultimately, but it can also be quicker than that, especially if either side has a motion that may be dispositive or it may carry the day for the case. Whereas sometimes folks will file in housing court or superior court, and those are not the primary venues for these kinds of cases. So they fall into the mix of the other types of cases that the courts have on their docket, and it tends to be quite a bit longer for those cases to get heard.
That's helpful as well. Thank you. And my last question, and I apologize, I only have the older version of the presentation in front of me, but with the cases that you showed, is there an example of the opposite? I think from my recollection, both were examples of a denial that, where the applicant ended up being able to show that they weren't, having the fair conditions met and going through it. Is there an example of the opposite, or is it typically that these follow the same as the Peabody and Taunton cases that you described?
Yes, there are examples. I tried to pick a few that were very recent. The one ended up being really recent, but there are examples. I'm happy to send one along, but they tend to, when it's, for example, in a butter and appealing, they tend to get into that line of analysis I mentioned about whether the abutter is actually aggrieved by the decision. So it sort of takes a different tact rather than even getting to the merits of the permit. A lot of those cases are knocked out or dismissed by an abutter who doesn't end up having standing. But I'm happy to send along an example of that kind of case.
Yeah, I was just thinking it might be helpful, and especially I appreciate the Massachusetts specific recent cases. It was helpful to be able to see that, so I'd just be curious. And thank you, Madam Chair. No further questions.
Anybody else with questions?
Actually, Madam Chair, one last quick question. On the case where if an aggrieved person comes forward and wants to challenge, say, the approval of a special permit, you mentioned how that, you talked about, solicitor, how that the person has to demonstrate how they are personally aggrieved. Does a case ever come forward where it's a group, like a neighborhood is, so then and I wouldn't know if it'd be class action, but like a group entity as opposed to an individual?
Yes. Sometimes there will be multiple different appeals of a special permit. And so for example, you could have a scenario where you approve a special permit, the applicant's not happy with condition 4 and 6, so they appeal that. And then one abutter, doesn't like it because of noise. One abutter doesn't like the traffic, and you could have multiple different appeals for different reasons. And oftentimes what happens in that situation is the court will consolidate the cases for judicial economy. But they will, more or less proceed along the lines of what we're talking about in terms of how they're going to be dealt with.
Does that answer your question, Councilor Wagner?
Well, since you asked, actually, no. So So say it's like, a mobile home park or a neighborhood that's made up of like 6 streets. So can the community come forward as one entity challenging, say, an approval? As opposed to like 6 people from the neighborhood?
Sometimes you see that, but they're gonna, then the issue will become, just as with an individual appellant, is does the entity, right, or does the organization have standing to prosecute the appeal? Is the organization suffering a particular damage? That's going to be the inquiry that's going to take place, and that's going to be their burden to prove ultimately. So it does happen sometimes, not as often as just various people appealing in their own right.
And to that point, I will offer, I believe one of the other changes that were made in the recent legislation can allow the court to put a $50,000 security when a plaintiff files an appeal. So that may stop some people from filing. I don't know why that was put in. Maybe you have more understanding if it was because the courts were feeling they were getting too many unnecessary appeals. That's probably not the right word, but, and it doesn't say it's required. It says at their discretion. So it'll be interesting to see how many courts actually do require that. I did want to bring up, is it okay to talk about an existing special permit in the city of Marlborough?
So it probably depends. It may depend on what's going to be said. I'd probably, especially if they're going to have any application coming before to modify that special permit, we wouldn't want to get into it. But a past example where that's not the case is okay.
And I guess it was more specific to the noise question. I think when Apex was before the city council, noise by the residents was a very big concern. We had a lot of discussion about the buildings, the air conditioning, the placement of the buildings, and it was approved. And then since then, I believe we have had several complaints by neighbors for noise level, and the Board of Health has been out there. So there are ways to mitigate if something is approved, at least noise level, to find out if they are in fact violating a noise level. They can be fined or they can be required to remedy the situation. So for that one, and I believe either the city council assistant or maybe the legal department would have the language of the appeal that for the city of Marlborough where we won the case. That could be interesting read for anybody that wants to read a case that we did win in the city. And I think I had sent information to the council on a class that I took that had a lot of cases that were both denial and that the case was actually was appealed, but the city was left with having the denial remain in place. So I think there are lots of options for reading material if you want other case examples that we can find. And again, I thank you, Solicitor Grossfield, for the presentation. I think it does give us all a lot to think about. I know we're all very curious about what's happening with the Chapter 358 Acts of 2020 and how it will impact Marlborough, specific to the fact that we are part of the bus station issue. We're an MBTA community, and so we fall under that specific language. So when you have more information on that one, I'm sure we'll be anxious to hear it. So,
absolutely. I'm happy to, of course, we're here for questions anytime, and I'm glad it was helpful tonight.
All right, if there are no other questions or comments from anybody, I think we are ready for our motion to adjourn.
Madam Chair, should we at least accept and place on file this excellent report?
We can certainly, I can take that motion.
Okay, so moved.
All right, it's been moved to accept and place on file the PowerPoint and comments from the solicitor. Is there discussion on the motion? Hearing none, we'll do another roll call vote. Councilor Landers.
Councilor Landers votes yes.
Councilor Wagner.
Counselor Wagner votes yes.
Councilor Doucette.
Counselor Doucette votes yes.
Councilor Navin.
Counselor Naven votes yes.
And Councilor Roby votes yes. So that is accepted and placed on file.
Motion to adjourn?
Have a motion to adjourn. I'll second that. And we'll do a final roll call vote. Councilor Wagner.
Counselor Wagner votes yes.
Councilor Navin.
Counselor Naven votes yes.
Councilor Landers.
Councilor Landers votes yes.
Councilor Doucette.
Counselor Doucette votes yes.
And Councilor Roby votes yes. Well, we are adjourned. It is 8:11. Thank you all very much for your time this evening. Thank you, Solicitor.